Uselove Web Radio, la voce dell'avvocatura.
E buon pomeriggio colleghi, ben trovati su Uselove Web Radio. Sono Andrea Pontecorvo, quest'oggi con una puntata assai interessante volta all'internazionalizzazione della nostra professione. Sapete che abbiamo particolarmente a cuore questa parte della nostra programmazione, quindi cerchiamo dei partner per le trasmissioni di più elevato livello contenutistico, in quanto riteniamo per l'appunto che tale debba essere la strada da percorrere. Quest'oggi il webinar è dello studio internazionale K&L Gates, uno studio, già potete tranquillamente ricevere le informazioni da parte dello stesso tramite il loro sito, ma anche tramite i loro social, K commerciale L Gates, e troverete ovviamente tutte le informazioni. Cosa ci aspetta da qui a pochissimi istanti? EU Political Climate, Employment Law Insights for Global Companies. In 2070, employers doing business in the EU are operating in a highly volatile political climate. France has a new president. The UK has a government with a reduced majority and an uncertain future. And Italy, as well as Germany, will hold election maybe later in the year. In addition, Brexit negotiations will begin imminently, giving rise to further strategic challenges for international businesses. Political changes inevitably give rise to changes in employment law. And in the latest of K&L Gates Global Employers Solutions webinars, partners from London, Paris, Berlin and Milan offices will offer insights on what these changes are likely to mean for the employment law landscape in each country, and will discuss what practical steps global businesses can take now in order to stay one step ahead on the changing political environment. Gli speakers, i relatori saranno Christine Artus, partner K&L Gates Paris, Paul Callegari, partners K&L Gates London, Matteo Heikki Einslor, partner K&L Gates Berlin, e Roberto Podda, partner di K&L Gates Milano. Questo tra pochissimi istanti. Tutti i relatori sono collegati dalle loro relative sedi: Parigi, Londra, Berlino e Milano. Pochi secondi ancora e davvero il webinar inizierà. Ovviamente il tutto in lingua inglese. Vi rammento ancora una volta che nel sito presso della radio, presso il quale sarà disponibile questo podcast, troverete anche il materiale che i colleghi illustreranno. E da parte di Andrea Pontecorvo davvero è tutto. Buon ascolto colleghi.
And I'm a partner at K&L Gates Berlin office. On behalf of K&L Gates, a very warm welcome to you all attending our Global Employer Solutions program titled EU Political Climate, Employment Law Insights for Global Companies. Our today's panel, we have partners from the major European jurisdictions who will guide us through their respective jurisdictions. We have Christine Artus, a partner in our Paris office, whose experience covers a wide range of individual and collective aspects of labor and employment law in France. We have Paul Callegari, a partner in our London office, who advises multinational companies on all aspects of contentious and non-contentious UK employment law. Roberto Podda, a partner in our Milano office, who represents multinational companies and large Italian industrial groups in union negotiations, business restructurings, layoffs, disciplinary measures, and employment disputes. And as I mentioned, I am Matteo Eisendohr. I primarily advise multinational companies on all matters of German labor and employment law arising from different types of commercial transactions and entrepreneurial activities. So before we begin, there are a few housekeeping items I'd like to mention. A PDF copy of today's presentation is available to you in print or download. You can access this document by clicking the Materials tab on the left side of your screen. You are encouraged to submit questions at any time throughout the broadcast by selecting the Forum tab on the left side of your screen. Type your email address and your question and click Submit. Questions will be addressed at the end of the program, and questions not addressed within our available time may be answered by way of a post-conference email. This program is eligible for CLE credit, and this webinar uses tracking software to ensure all attendees are actively participating. If you are not an active participant, the program will pause and you will require an action by you to restart. In order to receive CLE credit, you must actively watch at least 90% of the program and complete the program evaluation. You will not be able to download or print your CLE certificate without meeting the participation threshold and completing the evaluation. So let's start with today's webinar by introducing the agenda we have set out for this webinar. Could we have the slide, please? We will start by having a look at the current political situation that is considered throughout the webinar in the 4 jurisdictions we're having a close look at. We will then move forward to review the impact this political situation has on the employment and unemployment law, including reforms of the laws, before we then move on to having a couple of looks at practical steps. And then finally, we will, if time depending, we will review the questions you have asked and give further answers to those questions we will find. So let's start off by having a look at the current political situation in the various jurisdictions. And let's have initially let's have a look at France. France is currently, as we all know, very much in movement with a known political party of that name. So, Christine, give us an introduction to the current political situation in France, please.
Hi, thank you, Matteo. Yeah, in France, as you probably know, Emmanuel Macron was the Minister of the Economy during 2 years, from 2014 and 2016. He was a very young and new minister. He was not known at the time in France. In 2016, we had the crisis of the left government led by the President François Hollande. In May 2017, so last month, we had the election of a new president, Emmanuel Macron, who is young, new in the political spectrum, and not well known. So all the French people and French companies, including multinationals, are hoping that this new president will be very proactive and develop the employment in France. 9 days ago, June 18, was the election of the new French Parliament. The good news is that the new president obtained a large majority at the French Parliament, meaning that he will be able to implement the program he developed during his campaign. Next slide,
Thank you very much. Thank you very much, Christine. That is very decisive from a European point of view to see that France is moving forward at the verge of political stability. But what about the UK, Paul? Certainly stability is not really the word of the day there.
No, it's not the word of the day. In fact, you couldn't be less stable than the situation we have at the moment. It's by comparison to the French situation, unfortunately, we're in a bit of a mess. So this mess began last year, in fact. So David Cameron, having decided as part of his election manifesto when he was re-elected as Prime Minister in 2015 to promise a referendum on Brexit, almost in a way, I suppose, to appease the internal infighting that was going on within the Conservative Party at the time, where certain right-wing members of the party, including Boris Johnson and others, the more Eurosceptic members of the party, basically were putting pressure on him to have this referendum. So he agreed, and I think when he did so, he obviously assumed that nobody, or that the majority of people in this country would vote to stay in the EU. But as we all know, sadly that gamble misfired, and he was obviously required then to resign, since his position had been found to not be supported by the people of Great Britain. So he resigned, and somewhat surprising at the time, rather than Boris Johnson or another of the pro-Brexit campaigners becoming Prime Minister, it was Theresa May who stepped in and was eventually elected the new leader of the Conservative Party and therefore the Prime Minister. At the time, the Conservative Party had a majority in Parliament, quite a small majority. Theresa May had been quite clear all the way through since her original appointment that she would not call another election, and that she would see out the current Parliament until the next general election, which was due to take place in 2020, because we have 5-year terms. So she'd been quite clear all along. There's not going to be an election, and this is what we're going to do, and we're just going to get on with it. Theresa May then changed her mind, as all good politicians do. She changed her mind completely and called an election earlier this year, thinking that the Labour Party was in a very weak position, and also thinking that she needed a bigger majority than the one she had in order to force through her version of Brexit. So she called an election. And that's for the second time in a year, that gamble by a Conservative politician backfired. So what actually happened is that the Conservatives lost their overall majority. So the way our system works is we have 650 seats. So each part of the country is divided up into a constituency, and each constituency has one MP, and they're called seats, if you like. So 650 seats. Therefore, any one party to become an effective majority government has to achieve 326 seats, 326 MPs, which is 50% of the total plus one. Before the election, the Conservative government had a working majority of 17 seats. What they actually got was, after the election, was 317. So they were short of the majority that were needed. So the majority is 326. They were some way short of that. So what they have done, having all throughout their campaign warned of a coalition of chaos were Jeremy Corbyn and Labour to be elected, what they've actually done is spent the last 2 weeks negotiating their own coalition, and the final announcement of that was actually made yesterday. So they have reached an agreement with a party called the Democratic Unionist Party, which is a very small party from Northern Ireland. They've got 10 MPs, 10 seats, and they, in return for the payment by $1 billion, which is going to go towards Northern Ireland and various sort of infrastructure and economy projects, etc., the DUP has agreed that its MPs will support the Conservatives. So there were suggestions this morning that what was a hung parliament has now turned into a bung parliament. So the Conservatives have a majority, an effective working majority, thanks to the support of the DUP, of 13 members of Parliament, so 13 MPs, which is actually still less than she had before, and it's not going to take much, one would assume, for certain key votes to go against the government, because it only takes 13 people, 13 MPs on both sides, including her own party, to vote against something if they don't like it, and the Conservatives will not be able to pass any legislation or any laws that they would like to do. So the current situation is that Theresa May is still Prime Minister, the Conservatives are still in government. If we see a pattern of them regularly being defeated in the House of Commons, then it is not inconceivable that we will have a leadership challenge to Theresa May. We could have some kind of vote of no confidence, which would lead to another election, and we could have a Labour government, again within a relatively short period of time. So we are in a state of extreme flux, and which is not really ideal, given that the Brexit negotiation started a week ago.
Thank you, Paul. A very dramatic picture you drew about the situation in the United Kingdom. Now let's have a look at Italy. Italy has seen economic turmoil in the past, forcing the state to subsidize banks to avoid even greater economic restraints. So, Roberto, please describe a bit for us the Italian situation as it is today.
Yes, thank you, Matteo. Well, as to Italy, we can say that since 2013, the picture shown to international investors is of a general stability. In fact, in February 2014, the government led by Matteo Renzi came in charge to fall after the defeat in the referendum of 4 December 2016, which was called for to promote big changes in our written constitution, rejected by the Italian electorate. As a result, Mr. Renzi resigned, and on 12 December 2016, Mr. Paolo Gentiloni was appointed as the premier and formed a left-center government which represents the continuation of the political line of reform started by Matteo Renzi. In last May, the more representative political parties were close to find an agreement on a new law setting rules to regulate political elections. Agreement which should have led our country to election by next September at the latest. The agreement phase and prospect today is that the Italian government is likely to keep on leading Italy up to the natural expiration of the legislature currently in course, so that general national elections are likely to take place in winter 2018 within the context of a climate of general stability and of slow growth for Italy. I leave the floor to Germany.
Well, thank you, Roberto. The German situation is, as I guess we all know and read from the press, currently in a very stable environment. Germany is currently led by a so-called big coalition comprising of the two largest parties in Germany, the conservative Christian Democrats and the Social Democratic Party. They have been in government since 2013 and have been controlling roughly 80% of parliamentary votes. So in the parliament itself, we see the stable political environment that is currently underway. Germany has an extremely robust economic situation, leading to the lowest unemployment rate since unification in 1990, currently at 5.6% of employees. That is the statistics of May 2007. This is, although we all know how strong the German economy currently is, we must keep in mind that Germany in the early 2000s, 2001, 2002, was actually the caboose of economic growth in Europe and constantly not complying with the stability criteria of the European monetary zone. Therefore, there were massive reforms between 2002 and 2005 in both tax and social security law, as well as in employment law. This has now led to the situation, or politics recognize this having led to the political and economic situation we see in Germany. Germany is still in growth modus, with an estimated 700,000 new jobs to be created throughout this year. We are, however, already hearing warning voices that the German economy is too heavily dependent upon exports, and looking at the change of the global economic situation with a Brexit decision of the UK, with the new government in place in the United States, the two largest receiving countries of German exports, there are these warning voices that are pointing out that Germany must comply with the new situation going forward. Germany will be facing general elections of parliament on September 24th of this year, so in upcoming fall. The outcome is rather open as of today because the Social Democratic Party especially is currently very weak, and it is not quite sure whether the Christian Democratic Party would rather opt for another party, for instance the Liberal Party, to enter into a coalition. Whereas it is rather certain that Angela Merkel will remain Chancellor and in power of government. Now we have taken a good look at the different political situations in France, the UK, in Italy, and in Germany. Each are different, and in each of the economies, in each of the countries, this or the respective political situation, of course, impacts employment law and does trigger various reforms to get the economies of those countries up and running. So, Christine, would you please introduce us to what we think, or what France thinks the upcoming ideas, the upcoming reforms of Emmanuel Macron will be?
Yeah, sure. So in France, Emmanuel Macron promises different measures during his campaign. Very recently, the French government has published the timeline. So for the first and big reform which would concern the French Labour Code, the idea is to have a bill voted by the end of August. Tomorrow, the draft bill will be presented to the government, and the idea would be also to have all the bills implemented also by the end of September. So it will be a very quick speed reform, and hopefully the idea is to be to have less constraints. So first of all, the first reform will be on the French Labour Code. The idea of Emmanuel Macron is that having national collective bargaining agreements, putting rules on the negotiations within the company is not the right way. Emmanuel Macron believes that the best way would be to negotiate internally in the company to be more effective and to correspond better to the company's needs. So the idea is to have the collective bargaining agreements signed at the company level rather than at the national level. The idea also is to reduce the national branch collective bargaining agreements, which correspond to hundreds and hundreds of national collective bargaining agreements. In France, all companies in France do apply a collective bargaining agreement depending on its sector of activity. For example, consulting companies would apply the consulting firm collective bargaining agreement. So the idea is to reduce the numbers and reinforce any company agreements. However, Emmanuel Macron said that he will not change the working time rule. So meaning that in France, it will still be 35-hour work week. However, he will try to reduce the cost of overtime hours for both the company and the employer, meaning the employee. The employee will not pay social charges on any overtime hours, and the company will pay social charges, but at a very minimum level. The other aspect also is the digitalization of the French Labour Code. The idea of Emmanuel Macron is to provide access to all companies to the Labour Code. And the idea would be that the French government will have a website where the companies and employees could access to the Labour Code, and sometimes with some instructions, guidelines. Obviously, Labour Code in France is very complex. We have thousands of articles, and it might be difficult to understand, but that's the idea. So one other idea of Emmanuel Macron is that in France we have 4 types of employee representative bodies: the employee delegates, the Works Council, the Hygiene and Safety Committee, and the trade unions. Each of the body has specific powers and rights. The idea of Emmanuel Macron is to have a unique employee representative body, whatever the number of employees within the company. The idea of Emmanuel Macron also is to avoid the situation where companies do not want to have employee representatives or works council and then do not hire employees up to this threshold. Basically, in France, a company with at least 11 employees would have to organize employee delegates election. Companies with at least 50 employees would have to organize Works Council. Works Council is more complex, and there is a process of consultation of the Works Council. So the idea is to have a unique body, to simplify the dialogue within the company with the employee representatives, and to spend less time in that type of meetings for the managers. The other aspect also of the reform of Emmanuel Macron would be for the employees to increase their purchasing power. Today, employees and employers do pay social security contributions for social security, for retirement, and for unemployment benefits. It corresponds for the employee to approximately 23%, for the employer approximately 45%. Here, this measure is only for the employees, meaning that the idea of Emmanuel Macron is to eliminate the unemployment and social security contributions for the employees so that they have more purchasing power. Emmanuel Macron also is fighting against discrimination and equal treatment. He wants to implement a unique maternity leave, whatever the status of the person. Meaning that today we have different duration of maternity leave depending on whether the person is an employee, independent worker, etc. So Emmanuel Macron wants the same duration for maternity leave for all the women. Emmanuel Macron is also said also that his priority is on anti-discrimination measures and control. In hiring, in employment, so he would like to implement again more testing and control of the companies when hiring employees. The other aspect also regarding anti-discrimination for Emmanuel Macron is to fight against any discrimination against trade union members. The big point for Emmanuel Macron today and for the companies is on the first dismissal indemnities. So the idea in France, it's quite common when the employee is terminated by the company to go to court to obtain damages. Today, the amount of damages is not capped. There is a minimum amount, which is 6 months if the employee has at least 2 years of service within a company of 11 persons. However, there is no maximum amount. And in practice, realize that depending on the labor courts, we could find very, very different amount of damages. For example, in Paris, it could be lower than in the south of France. So Emmanuel Macron thinks that it is not equal treatment between the former employees, and from an employer perspective also, he wants the company to assess what could be the maximum exposure for a company to for a dismissal, for an unfair dismissal. Today we do not have any amounts. In the draft bill, there is no reference for the time being for any maximum amount, but the idea is that this maximum amount would apply to all type of dismissals, except for discrimination and moral or sexual harassment. The other idea of Emmanuel Macron is because in France, when you terminate an employee, you have to justify from a real and just cause. The idea of Emmanuel Macron is to render less complex and easier a termination for economic reasons of an affiliate in France facing financial difficulties, and this affiliate belongs to a group, an international group. So the idea is to render less complex the termination of this type of employees. The other idea, because in France in France, when you terminate an employment contract, if you dismiss the employee is entitled to be paid by the French government, what we call unemployment benefits. This is the reason why probably in your company you are facing the situation where an employee should actually resign, but says, no, I don't want to resign. I want to be dismissed by the company. So we are facing a situation where the employee to be dismissed would put the company in a situation where the company does not have any other choice but to terminate the employee, even for gross misconduct. But even in case of gross misconduct, the employee would be paid by the French government unemployment benefits. So facing this situation, Emmanuel Macron is considering now that the employee who resigns from his current job would be entitled to be paid unemployment benefits, of course subject to certain conditions. Equally, Emmanuel Macron would like to simplify the situation because today only employees are entitled to unemployment benefits, whereas independent workers do not. So the idea of Emmanuel Macron is to simplify and to allow all persons who is terminated to be able to be paid unemployment benefits. On the retirement aspect, today Emmanuel Macron does not want to change significantly the law on retirement. Basically, the legal retirement age will be still at 62 years old, and we do not expect very significant changes in that respect. As you do see, it is a summary of the main project of Emmanuel Macron, and he said that most of these will be implemented, and in particular the capped amount as damages before labor court will be decided by the end of September of this year. The rest of the program will be over the next 18 months. So my recommendation for all employers in France, of course, is really to follow up on coming changes in the labor code, to consider what are the changes to be and how it will impact your business in France. Also, the main change also will be to consider a unique employee representative body within all companies in France. What type of employee representative, what would be their power, and how it will impact your business on a day-to-day basis. And for sure, look out for discrimination. It is still the case in France, but in the future it will be more important. The good thing for the company would be that we will be able to tell you exactly what could be the capped amount in case there is any court action initiated by an employee that your company would have terminated under French law. In any case, settlement agreement or mediation are still a good option to avoid any court action. And also, more importantly, as HR persons also, you know that the relationship with the employees, the relationship with the employer representative, and the relationship with the labor inspector is really key to minimize your risk within your company.
Thank you very much, Christine. It's surprising how employment is on the top of the agenda of Emmanuel Macron and how important he regards employment to be for a positive economic development, since these developments, these ideas of reform are, to my understanding, the next thing he wants to tackle. Moving on to the United Kingdom and immediately after elections there, Paul, please be so kind and outline what to expect in the UK given the shatters of Brexit and the past elections.
Sure. So what I'm going to go through is what's contained in the Conservative Manifesto. and that is the document that they published before the election to explain what they would like to do and what changes they'd like to bring were they to be re-elected. This obviously comes with a slight health warning because in order to secure the assistance of the DUP, the Conservatives have had to admit that they have dropped large parts of their manifesto, especially those that are, should we say, more controversial and more unpopular. So we don't fully yet know which parts of this manifesto they're going to implement. The other thing to bear in mind is that because of their working majority, even those parts of the manifesto they may seek to implement, they may be unable to do so if certain measures are outvoted or not supported in House of Parliament. So just because these things are here, it is by no means certain that some of them will ever see the light of day or will ever become law. Last week we had the Queen's speech, which is a speech written by the government but given by the Queen, in which she reads through the sort of highlights, if you like, edited highlights of the legislative package that the government intends to pass through in the next Parliament. And it's certainly true to say that some of the more controversial elements of the Conservative manifesto outside of the employment world have been abandoned by the Conservatives. So we will wait to see how much of this ever comes into existence. But the first point, I think, is undoubtedly going to come into existence, and that's the guarantee of EU-derived employment rights. The government is going to implement what they're calling the Great Repeal Bill, the effect of which is to effectively collapse all EU-derived legislation into domestic UK law. And they said that all they're going to do is just transition it directly into UK law, and they're not going to change anything. So those people that are concerned about employment rights disappearing overnight as a result of Brexit, those concerns are unfounded, at least in the short term. What it does mean, of course, is that once a measure becomes part of domestic UK law and no longer constrained by the underlying EU directive which supports that law, it means that any government or any domestic UK government is then free to change those laws as soon as they can get the majority will to do so. So certainly in the short term, no change to EU-derived rights such as working time, paid holiday, TUPE, those kinds of things. But in the longer term, we may well see some domestic changes on the agenda. One thing that they have said that they're not going to bring over is the European EU Charter of Fundamental Rights. So the government supposedly is concerned about whether our ability to prevent terrorism is constrained by the current human rights framework, and they're going to look to address that. You might think that human rights is exactly something it should be protected at this time rather than the opposite, but they are going to be looking to amend that. They said that the Human Rights Act 1998 will be retained while the process of Brexit is underway, but they will consider, this is the quote, they will consider our human rights legal framework when the process of leaving the EU concludes. So it's going to be up for grabs at that stage. One thing that certainly is going to be brought through, because it was in the Queen's speech, which is an increase to the national living wage, and that's the minimum wage which applies to workers who are aged 25 or over. So that is going to continue. The national living wage is going to continue to be increased in line with the current target, which is for the rate to reach 60% of median earnings by 2020. So that's going to continue to increase. They will also continue with again, this was something that was in the Queen's speech. There is a review ongoing at the moment into the gig economy. Those of you that have dialed into previous webinars that we have given will know that there have been a number of legal test cases brought by Uber drivers, brought by couriers working for various courier companies, regarding the validity of their supposed self-employed status. And some of those individuals have succeeded in claiming paid holiday rights and minimum wage entitlements and similar. So this has prompted a cause for a review into whether there are certain companies which employ a lot of people whether they are abusing their market powers, whether they're abusing their powers as employers, and that's something that is going to continue, and that review could result in changes to how we structure our employment models and our employment status arrangements in the UK. The next item, the last item on this slide, worker representation at board level, is something that's slightly surprising. In one sense, one might think that having increased worker representation in a situation where the UK currently doesn't really have much representation, we have trade unions, but they're not particularly strong. We have nothing like the level of Works Council's involvement or employee representation involvement you'd see in other countries such as France or Germany. And you'd think that this type of worker representation initiative would be something that would traditionally be proposed by a Labour government rather than a Conservative government. But actually it's something that's been on Theresa May's agenda since the very beginning of her days as Prime Minister. So that's continued, although critics have claimed that what made it into the manifesto is very much a watered down version of what she has previously spoken about. So this worker representation idea, so the first point is it applies to PLC listed companies, which is companies fully listed on the London Stock Exchange. It doesn't, at the moment, it's not going to apply to privately owned companies, although whether we see sort of good practice develop or additional companies brought within the scope of the legislation may be something that comes later. But in the short term, PLC listed companies will be required to either nominate a board director from the workforce or to create a formal advisory council, employee advisory council, or to assign specific responsibility for employee representation to a designated non-executive director. So this is unlike anything that we have or have ever had in terms of internal employee representation. So it's interesting that they're going to continue with that. The next item on their agenda is is additional leaves. So we already have paternity leave, maternity leave, parental leave, the right to request flexible working, the right to take time off to deal with domestic emergencies. So they're going to extend that to the right to request leave for training, the right to take time off for sick relatives, and the right to child bereavement, the right to take time off to deal with child bereavement. All of these will be unpaid, and it is the right to request rather than the right to be given this additional leave. So all of these are proposed to be added to the range of time off, or the categories of time off that employees can request. The other thing they're going to be looking at is an extension of the scope of our disability discrimination legislation. Disability discrimination at the moment under the Equality Act 2010 already covers many mental conditions, but in order to qualify for protection, the employee has to show that there is a long-term, by which I mean 12 months or more, condition which is likely to have a substantial effect on the individual's ability to carry out day-to-day activities. So what the government is proposing is to deem effectively or categorise certain illnesses as automatically protected by disability discrimination, regardless of the impact on the individual or the length of time that the condition will last for. Currently, things like cancer are automatically a disability. It's thought that the government is going to look to extend the scope of that protection to depression, anxiety, and bipolar disorder. So if an employee is suffering with one of those, then they will automatically be protected by the Equality Act. The next step there is Gender Gap 2.0. So many of you will be familiar with the fact that as of this year, we've had the requirement for certain companies, certain large companies, to make available what's called gender pay gap reporting. So they need to provide an analysis of pay, which is or levels of pay on offer to male and female employees, and to provide average statistics in order to demonstrate or hopefully demonstrate that both sexes are paid at an equal level. The government is proposing to extend that to races, so the same analysis will need to be done, but based on ethnic origin rather than gender. Now, the final point, of course, which they haven't mentioned, is the abolition of employment tribunal fees, and there is no suggestion that they're going to do that. So it may well be the case that employees derive lots of additional rights in the course of this manifesto, but they still cannot do anything, or effectively do anything to protect those rights without having to incur personal costs, which is the case at the moment. So doesn't appear to be something that's going to change. Finally, given that they are technically not technically, but given they are on the side of the government, it's worth a quick look at the DUP. The DUP would rather like a soft Brexit, where I think if one thing's going to be clear is that we're not going to get a soft Brexit, and we're certainly not going to be looking to continue free movement of people, so that may well create some sort of internal tension there. And the DUP has made it clear in their manifesto that they would like support to continue support for existing workers' rights, which, given the Great Repeal Act, doesn't appear to be something that should cause too many issues. So, in terms of practical tips for employers doing business in the UK, the first and most obvious thing is to keep abreast of Brexit negotiations, which start on the 19th of June. Many people have seen yesterday that the government announced or confirmed its proposals as to how it's going to deal with EU residents that are here at the moment under free movement principles. They've provided some proposals which are proposals. They're not, these are proposals to be debated with the EU as part of the Brexit negotiations. But they've provided for those people that have been here for 5 years to stay. They can have settled status. They've got to apply for an identity card, no doubt at a cost, which has caused a slight amount of concern. Those with less than 5 years' time in the UK can stay on until they reach 5 years, and those that aren't that fortunate, or those that arrive after a cut-off date, are going to be subject to certain immigration control they're not currently subject to. The government's proposals in this regard have been criticised by various business groups as creating or doing nothing to ease the uncertainty which currently surrounds EU nationals and their employers. The various employers' organisations have been very critical of these proposals. The EU has been very critical of them. So we will have to see where these proposals finally end up. But undoubtedly going to be plenty of twists and turns coming in part of the Brexit negotiations, so stay up to speed with those. If you are listed on the London Stock Exchange or are planning to be, think about how you're going to deal with worker representation requirements and the path of least resistance that you're going to choose in order to satisfy those. Have a look at your existing policies and think about how you're going to accommodate these new leave rights that I mentioned, the rights to request time off for certain things. Have a look at how you're going to build those in, and it may be that these are the sort of things that you operate on an informal basis already. And the final thing I would suggest is a lot of companies, before the gender pay gap regulations became law, a lot of companies did their own internal audit to consider whether they would be compliant or not, in the hope of giving themselves some time to address any gender pay gap. You may wish to consider doing the same exercise with regard to employees of different ethnic origins, so that if there is a problem, you're able to identify it and address it before the requirement to publish those sorts of statistics. And that is it from the UK. Thank you very much.
Thank you very much, Paul. Not too much to be said, but we'll have to keep our eyes open on what's going to happen in the UK. Roberto, what is next in Italy? Any clear reforms to ramp up Italian economy?
Yes, it is. It is. To fully understand the impact of the current political climate for companies and employers in Italy, we have to start from the end of 2014, beginning of 2015, when Italy started to implement and put into force deep reforms aimed at achieving a higher level of flexibility within the Italian labour market, commonly seen as one of the most uncompetitive and rigid in Europe. The measures were implemented following the recommendations of the European Commission and Council, which urged Italy to make additional efforts to be in compliance with the requirements of the Stability and Growth Act. With specific regard to the Italian labour market and to the domestic regulation of employment relationships, the European institution highlighted the key role of the enhancement of exit flexibility, along with better regulated entry flexibility, a more comprehensive system of unemployment benefits and better alignment of wages on productivity in order to promote growth. It is a so-called flexicurity. Therefore, so inspired by the European institutions, the Italian government, led by Matteo Renzi, pushed for the entering into force of a revolutionary package of legislative decrees, the first of which came to light in March 2015, and the last one in May 2017. The entire reform package is known as the Jobs Act. The provisions, including in the Jobs Act, represent the Italian government's response to European Union recommendations, with a view to creating a more inclusive and dynamic system, overcoming the remaining segmentations and rigidities, and thus promoting the occupational and production growth. In particular, the declared goal pursued by the former Italian Prime Minister was to encourage employers to recruit new staff, also with the introduction of special tax and social security savings for employers, to remarkably reduce the level of litigation surrounding the employment relationship, and generally to simplify the existing employment law in Italy. But above all, mainly, a special emphasis is undoubtedly to be given to the deep changes made in the field of individual and collective dismissals, which reveal the determination of the Italian legislator in driving the overall rationale of the national labor law system to a clearly new and almost revolutionary inspiring principle, which was never experienced during the course of the last 50 years. Indeed, the need to protect employment and the general capability of the entrepreneurs to create new employment now prevails on what has been considered as the sacred cow of the Italian labor law, i.e. the individual employee's right to be reinstated in their job position in case of wrongful dismissal. So the real turning point is represented on how the flexibility offered by the new discipline regulating the consequences of an unlawful dismissal has led to supersede the traditional favor devoted by the Italian legislator to employees since the so-called Workers' Statute of May 1970 came into force as the outcome of the well-known blue collars and trade union riot season that went across Italy in the latest 60s. Next slide, please. So, what are we talking about? What does it mean, such deep reform implemented through the legislative decrees constituting the Jobs Act? In a nutshell, the most important part of the Jobs Act regards the dismissal regime, which has been simplified and became less onerous and costly for employers. As a matter of fact, for almost 50 years, the rules set forth by the famous Article 18 of the Workers' Statute entailed that a company employing more than 15 employees in each local unit or more than 60 in the aggregate and willing to terminate an individual other than an executive, either for serious misconduct or due to redundancy, was forced to reinstate the affected employee in his job position in case the dismissal served was found wrongful or unlawful by the competent labor court. In March 2015, the Italian legislature remarkably opted to confine the application of reinstatement to very limited cases, essentially discrimination and retaliation, so suppressing the full job for life protection guaranteed by Article 18 and launching its challenge to encourage companies to hire new staff and to attract foreign investors back to Italy. Furthermore, through the Jobs Act, the types of employment agreements have been simplified and reduced in order to enable and incentivize employers to hire workforce under open-ended employment agreements. New forms of flexibility for the benefit of employees were also introduced to allow them to find the right compromise and conciliate work with private and familiar life. Again, the Italian legislature gave a new structure to unemployment benefits and public redundancy funds, in order to promote requalification of unemployed people. And significant innovation were also introduced in respect of self-employed contracts, employers' unilateral power to demote an employee upon given terms and conditions in order to avoid dismissal, extension of maternity entitlement, surveillance over employees' activity in the workplace, and finally, smart working, whereby employer and employee are entitled to agree that working activities can be remotely performed through the use of modern technology and without any obligation for the employee to comply with a given working time and to perform activities necessarily within the company's premises. Furthermore, and most remarkably, through smart working, employer and employee are entitled to focus on goals and objectives to be pursued and to determine even a significant portion of the salary on goals and objectives with the aim to increasing the employee's productivity. Next slide, please. So as you can see from the slide, such deep reforms led already to certain positive effects within the Italian labor market. You can appreciate that the picture changed from January 2014 up to date. Employment rate increased along with the aggregate number of people employed, and increased proportionally to the reduction of unemployment rate and of the aggregate number of people unemployed. Next slide, please. So what's next? We can say that the systemic revolution obtained through the Jobs Act represents for Italy a turning point and, in our opinion, an irreversible step, so that it is highly likely that, irrespective of the outcome of next general election, irrespective of the next winning political party or coalition, the picture should not change, and reforms introduced in the Italian labor market will be not dismantled. Next slide, please. So as a conclusion, and in light of all we said before, employers should remain confident that picture is not going to change in the next future, and therefore they should direct their labor and HR strategies by relying on the opportunities offered by a more flexible system, which again is not going to be changed. So recommendations are: keep on hiring workforce under open-ended employment agreements. Be careful in not discriminating your employees who, if dismissed due to discrimination or retaliation, may obtain reinstatement. If you are considering individual dismissals, please also consider the relationship between the employee's seniority and related costs to be sustained. In fact, for employees hired starting from 7 March 2015, dismissals costs and indemnities are higher for those employees with a higher seniority. If you litigate with a dismissed employee challenging dismissal, settlement is definitely less costly than a labor lawsuit, so seek for settlement. And lastly, consider smart working as a real option, whereby you can award more productive and proactive employees. So the floor again to Germany.
Thank you very much, Roberto. It's a very encouraging fact that a smart and almost revolutionary policy in Italy in employment law has led to really positive results, as we see in the figures you shared with us. So thank you very much for that. Let's move on and have a look at the German labor reforms. And actually, given that we have general elections in Germany only in autumn, so in only a couple of weeks from today, in the mid-end of September, we should rather look back and see what has happened in Germany. To put it straightforward, the political parties currently are in the midst of creating their party programs. They will then offer to the electorate vote to decide upon, and there's really not too much to describe, as Paul did earlier on with respect to the United Kingdom. But looking back, what were the main things that happened in the past 4 years of the legislating period in Germany under the big coalition? Well, the first and very strong introduction we saw in Germany was the introduction of a minimum wage. Currently at €8.74, it will rise to about €9 within the year of 2018, the minimum wage, very fiercely fought against by the Conservative Party, very much supported by the Social Democrat Party, has actually led to an increase of private spending because people have more money in their pockets, with positive effects for taxes, and thereby has also led to a higher degree of employment. So there is a link of minimum wage and an increase of employment in Germany. Furthermore, there have been very strong restrictions on so-called leased labor, where individual employers may lease an employee from a leasing company and employ this individual within his own company without having the risks of termination laws under German law, which are quite strict. This has been misused for quite some years by German employers, and it has been one of the promises of Angela Merkel throughout the campaign 4 years ago to restrict leased labor, and that has happened. The same applies to reducing the risk in the misuse of alternative agreements, for instance, service agreements or work agreements, whereby German employers employ freelancers but actually involve them within their businesses as if they were employees. Freelancers are not protected by the strong and very fierce anti-termination laws of Germany, so that was once again a backdoor for very many employers to dodge those laws. It has been implemented, or the German legislature has implemented, a new law clarifying what employment actually means, and this definition is very broad and makes it difficult for employers to dodge the laws protecting individual employees. Finally, women's rights in general have been strengthened, especially through two legislative measures. One, putting up an obligatory degree of women on supervisory boards of companies that are traded publicly, especially the DAX companies. Before the law was passed, we had 2 women on supervisory boards of DAX companies. That has changed. We're moving now currently to the degree that we have 20 to 22 women on supervisory boards. Additionally, we have implemented a code that allows each and every employee to demand from his employer an overview of the income of his peers within a company. This is mainly passed, or this code has been passed to protect women, because statistically women have been paid about 10 to 15% less in salary and wages than men in their peer positions. The new law now enforces the rights to receive further information and then claim for damages for the balance payment of what has been paid to peers and what especially women have received as less or as a minimum amount or minimal amount of money. What we've also seen throughout the past 4 years was a strong initiative dealing with the new digital world in employment, Working 4.0, or as the Germans call it, Arbeiten 4.0. After various industrial revolutions in the past, the new type of work in our new digital world is regarded to be the fourth and very, very major revolution. The competent Ministry of Labor has passed a so-called white book, including a definition of what Arbeiten 4.0 means, also taking up the risks and the chances of this new type of work, and also displaying what must be changed throughout the German labor law system to cope with those challenges of the new digital world. No legislative actions have been taken so far, but there are some that are upcoming. For instance, the change of working hours, which will not be based on a day or week related scheme, but maybe on a month related scheme. Also, there will be changes as we see it in collective codes when having a look at the relationship between the employer and the Works Council. The definition of a works has been or has become a bit difficult, especially with respect to new types and new forms of work, be it working at home or working from abroad. So what is next? What do we see in Germany? Well, all signals are quite encouraging to the German economy that the development with a very strong and robust economy will continue. However, as I spoke earlier, there are tough risks with respect to the global or the export dependency of German economy and the global economical changes. The economic development, as described above, as well as the demographic situation in Germany, where we see a society that is growing older and older, will require highly trained specialists to support the German industrial sectors, and therefore investments into education will certainly expand and require state support. The parties are discussing the possibilities of state support for people who maybe lost their jobs and now are seeking new jobs in a totally changed world thanks to the new digital era. There are long discussions about that, and that will certainly be subject to the upcoming elections. The outcome of the autumn elections is, however, not really decisive for the development of employment law, since we are currently in a very stable situation and great changes, especially, but no greater gifts to employees, giving them greater influence upon their employment relationships, that is not expected. And finally, tackling the digital challenges will be on the agenda, whatever happens and whoever is in power, because the changes we are encountering in the scheme of employment are very, very fierce and very radical. When it comes to recommendations for employers moving forward, active on the German market, we will all see a great fight for talent in the future. Therefore, it will be important to create terms of employment that are competitive on the market in order to win in the fight for talent. And finally, be prepared to face the challenges through the digitalization of employment and of Arbeiten 4.0. If I see it correctly, we would move now on to questions and answers. Given the time we've already spent, and also the fact that, if I see it correctly, we have not received any questions, we're always up. The four faces you see on the final slide, you will see all contact data. Please do feel free to reach out to us at any time if you have further questions and if we can be of any help and support. Thank you all so very much for participating in today's webinar. If you have any questions, as said, please contact any of us at any time. Our information can be found at the end of the PowerPoint slides, as I've already indicated. If you would like to hear this presentation again, you can listen to it as it's been recording, as well as other on-demand CLE courses at klgateshub.com. It was a pleasure for us all to hold this webinar, and we wish you all a wonderful rest of the day.
Uslov Web Radio, la voce dell'avvocatura.
E termina, come avete sentito, questo webinar organizzato da K&L Gates Studio Internazionale. Collegati erano da colleghi da Berlino, da Parigi, da Londra e anche da Milano. Noi ringraziamo ovviamente lo studio K&L Gates per questo importante prodotto che abbiamo trasmesso anche su Uslow Web Radio. Torneremo ovviamente con altri webinar sempre interessanti, sempre rivolti alla internazionalizzazione della professione. Ricordo ancora una volta che tra poche ore sarà disponibile tutto il materiale di cui al presente webinar anche sulla pagina che stiamo già creando per il corretto posizionamento sul nostro sito del webinar stesso. Potete scriverci a webradio@uslow.it oppure mandarci un SMS, WhatsApp o Telegram al 331 309 7852. E davvero, da Andrea Pontecorvo nella sede romana della radio è davvero tutto. Ci risentiamo con la normale programmazione di Uslow Web Radio. Cari colleghi, care colleghe, cari colleghi, un caro saluto e ci risentiamo presto.
Uslow Web Radio 331 3097 852 www.webradiouslow.it. Ascolta quando vuoi e dove vuoi Uslow Web Radio, la radio per gli avvocati fatta da avvocati. Scarica la nostra app per Apple e Android. Tutti i giorni.